To begin, we have Daphne and Pete here are going to be our main speakers. So Daphne is a partner at Perkins Coie Technology Transaction and Privacy Group in Silicon Valley, and she plays an integral role within the firm's emerging companies and venture capital practice. And Pete is an associate at Perkins Coie's Technology Transaction and Privacy Group in Silicon Valley as well, where he structures documents and negotiates strategic transactions involving technology and advises clients in intellectual property issues in large corporate transactions, such as mergers and acquisitions. So I'm going to hand it over to them. Thank you, guys.
Hey, good morning, afternoon, folks. We're absolutely thrilled to be here. I do want to mention, before we kind of delve into the content, I want to mention that we are the proud sponsors of the Venture Bridge program, you know, the bridge from Pittsburgh to Silicon Valley, and really encourage folks to check that out. I mean, this is where we connect with you, in addition to, you know, this talk and some other things. So look forward to seeing some folks there. And I'm gonna now pass it over to my colleague, Pete.
Hey everyone, not much to add to the intro, but very pleased to be here and looking forward to the presentation and to talking a little bit about how to monetize your IP.
Bring us the money.
Yeah, so I think we can probably get started, unless there are any initial questions or comments about either of our backgrounds or anything.
Yeah, and one thing I just want to, you know, what Allison mentioned about questions, please. I mean, this is really an interactive session. We want to make sure you get the info that you need. So please ask questions whenever.
Yeah, and just to piggyback off that, it doesn't have to be related to the current slide or anything like that, you know, and you know, anything that comes to mind, whether or not you think it's totally applicable to the subject matter we're talking about, just feel free and shoot a question, and you know, don't worry about interrupting or anything like that. We want this to be as much of a dialogue as possible. So yeah, without further ado, we will get started.
Yeah.
I'm going to try to share my screen. Let's hope that this works.
Yeah, and so as Pete gets the slides up, what we're going to do is we're going to go through some core IP concepts that you need to know in order to kind of delve into licensing, where you would be able to monetize your IP. So, you know, as I just mentioned, starting off with core IP concepts, and then delving into the real body of what we want to cover, and that is, you know, how do you take this stuff that you own, that you've created, and make money from it?
Yes, I'm going to try to present this. Sorry, I'm trying to figure out how to get this into actual presentation mode here. All right, well, maybe we'll just do it as a slideshow. Okay. Cool, so as we mentioned, title, Show Me the Money, Monetizing IP via Licenses. So we're gonna sort of talk about how to do that. Here's the agenda. So we'll start quickly with going over some basics about IP, you know, sort of the main forms of IP, what they protect, what they don't. Not going to spend a ton of time on that, but, you know, we want to talk more about these, you know, sort of how to monetize that IP. If you've created something, how to take it and do something with it, and what terms you would need to have in place for that kind of business relationship and things like that. So that'll be the what and why of licensing. We'll talk through, you know, the anatomy of a license agreement, sort of key terms that each license agreement will generally contain. And then we'll finish with what we're calling traps for the unwary, which are some common issues that percolate with almost, very frequently with startup clients that we work with, that are sort of gotchas that by working with an attorney you can proactively avoid. So really quickly, it's useful when you're thinking about intellectual property to think about the distinction between what intellectual property rights are and what technology is. So if you have, for example, a piece of software code, there are intellectual property rights in that code. Those are your intangible rights. In this case, it would be copyright generally. And then there's the code itself. The code itself is generally technology, and the underlying IP rights are what we generally refer to as intellectual property. So the right to control others' use of in this case, your software code is what we call your intellectual property rights.
Yeah, and to just at the very beginning, when you're starting your company and things like that, and this is just kind of a quick tip, is that you want to make sure that if you have a team of people working on your code or whatever product you're creating or some invention or whatever it is, that it's really clear that anything they create is owned by the company. What we find so often is like something really cool is created and we're about to license it, or there's a financing where you're getting some money in for the company, or you're being acquired, and it turns out that the company actually doesn't own its IP. So a developer developed some of that code, and it was developed by the individual, but it wasn't properly assigned over to the company. So as a tip, just make sure that when you've got a team working with you, they've got documents in place that ensure that the company owns all of the IP.
Yeah, and I'd also like to add to that point, it's a good one, but also if you are a founder, let's say you're co-founding a company and you and your co-founder have been doing some development work, but it's pre-formation, you haven't actually formed the company, and then you form the company and you're sort of going forward with that, using that IP or using that technology, I should say. You're going to want to make sure that you have documentation in place to bring the things that you founded pre-incorporation into the company as well. We frequently see with founders, that they'll set up a company, will get the documents in place for their first couple employees and some of their first couple contractors, but they haven't actually assigned founder IP that they've created before the company was actually formed. So that's something you'll also want to keep an eye on going forward when you are starting to ramp up. So we'll go through the basics of IP real quick, sort of the different types. The first type that we'll talk about is copyright. Copyright is national. Each country has its own copyright law. Obviously, we'll focus on American for the purpose of this presentation. Generally, copyright is going to protect works of authorship. So again, using the software example, if you type a line of code, that's going to be generally protected by copyright. And copyright, unlike patent, is automatic. So I frequently, when I'm talking to my friends, they'll ask, oh, well, how do I register for my copyright, or what do I need to do to get my copyright? The answer is basically nothing. I mean, the copyright is automatic on the fixation of the work. So let's say you're writing a chapter of a book, it's your book, and you write a chapter, you have a copyright in that chapter, in that book, without having to register it before any copyright office. So common sort of misconception about copyright.
Yeah, and just to back up a teeny bit, as Pete was saying, you've got code, and then there are all these other, and that's kind of the tangible kind of technology. and then there are all these separate intellectual property rights. And it's like different buckets of rights. So you've got a bucket of copyright, which is what Pete just talked about. Then there's another bucket of trade secrets, which we'll touch on soon. And then another bucket of trademark rights. And then a final bucket of patent rights. So we're going to whiz through these, but I just want you to understand that there's this kind of the code thing here and then buckets of rights.
Yeah. Thank you, Daphne. That's a good point. There are certain enumerated rights that you have with a copyright. The copyright holder has the exclusive right to do certain things, and that's granted by statute. We list those here, but one of the, for example, copying. So if you write a book, you have the exclusive right to make copies of that book. Patents. Unlike copyright, patent is patent is something that you need to file for protection. So, you know, patent, like copyright, each country has its own patent law, but patents generally protect new, non-obvious, and useful inventions. And patents are awarded by the government, so you need to go through an extensive filing process, or an extensive application process, where you present the patent to the government and the government evaluates the claims that you're making on the patent. And yeah, patent, we don't frequently see software protected by patent, but it has been in the past. Much like copyright, patent has certain enumerated rights or exclusive rights. So if you have a patent on something, you have the exclusive right to make, use, sell, offer to sell, or import the invention, which is usually a product that's based on those, based on the patent. And that's, we'll get to how you license those rights in further slides.
And the reason we're going through this, as I mentioned at the beginning, is to really make it clear that you have an understanding of all these different rights so you can exploit them in the appropriate way and get what you need from your IP, which, you know, is really the crown jewel of your company. Also, again, it's helpful to understand these rights to ensure that you own all of these rights in the products or services that you are providing or would like to provide to others.
Next category of IP is trademark. So just generally words, phrases, or symbols that identify source of goods. So think the Nike swoosh, the Target logo, things like that. Usually not a lot of action in a software license about trademark, but one thing that you will want to keep in mind, and we'll double back on this when we talk about licensing agreements, but you always want to make sure that you have terms that sort of govern the other party's use of your trademark, or else you can be found to have abandoned the trademark. And we can talk more about that at the licensing stage. And then finally, we've got trade secret. Trade secrets are information that have incremental value if kept secret, and the owner takes reasonable efforts to keep secret. So the example I most often like to use is the Coca-Cola formula. That is protected as a trade secret by Coca-Cola. You generally, you know, a trade secret is information that you want to keep secret and that you're using efforts to keep secret, i.e. you are subjecting another party to confidentiality restrictions and requirements. And the benefit of a trade secret, as opposed to protecting something with patent or copyright, is that a trade secret is indefinite as long as you're taking steps to protect it. So trade secrets can often be useful ways of, you know, sort of categorizing IP and protecting it.
Yeah, and this is where you kind of see like all the stuff in the press about things. You've got someone at company X who has been working on some, let's say, nifty robotics product, and then they decide, I'd really like to go to company Y, who's also working on similar things. And company Y thinks, yeah, this candidate is pretty attractive because they already have this experience. So the candidate goes over to company Y and, shares the stuff that he learned at company X. Now, that is sharing a trade secret of company X. So, if you're starting your company and you're looking for people to join your team, yeah, you certainly want someone who has experience in the area, but you have to be very, very careful. They do not share anything they learned in their employment with the other party, with you, because that will open you up to a big lawsuit. And, we see this happening all of the time, and these can be pretty major lawsuits. So it's when you're bringing folks on board, while you want that wonderful expertise, just keep a lookout and make sure they're not disclosing stuff from their company they ought not to.
Hey,
That's our sort of overview of IP 101, and now we'll start talking about a little bit more substantive issues and how these sort of relate more to your business, and how they relate to licensing and licensing agreements. So one thing we wanted to talk about, our slide is called "Who Owns the Crown Jewels," but it's basically who owns the IP. And this can be a complicated issue, particularly when we have a few scenarios we want to talk about, but there are institutions, accelerators, and other third parties that we wanted to discuss with particularity. I think, Daphne, you wanted to start with universities at least.
Yeah, and so, we've kind of touched on these issues already. The whole concept being, you've got this really nifty IP, great products, services, whatever, and you want to, in order to get any money from it, you need to ensure that you fully own it, or at the very least, you have a license to use it the way that you want. And what we see is that there are a lot of companies coming out of universities now, and someone who's at the new company, was a TA or a professor, or a grad student that's being paid. So in any sort of capacity where they were an employee. And so that person has signed an agreement with the university that states, look, anything you create using the university's resources or that relates to the work you're doing for the university is owned by the university. And so if you're utilizing someone that's from a university, or if you yourself are that person, you want to look at your employment agreement with the university to fully understand what rights they have and what you're creating. But usually they have all of the rights in it. So what ends up happening is that the universities have these licensing bodies that will license the rights to what you've created at the university that relates to the company that you're working for to the company. But you have to make sure that if you've created anything at the institution, what rights do they have? And if they have rights, those rights need to be licensed to your company.
And then I think, similar issue with accelerators, right, Daphne, where
yeah, exactly.
Generally when you're, you just always want to think when you're working with an accelerator, a university, any sort of you know, maybe an incubator, any sort of body that's going to be, you know, sort of you're working somewhat collaboratively with, you'll always just want to think, you know, what documentation am I signing? What policies are in place with between myself and these universities or accelerators or incubators or what have you? And you'll want to just, you or your lawyer will want to do your diligence on looking those policies up and understanding them and understanding the implications for how the implications on the things that you create while at those institutions or accelerators, right? And as Daphne mentioned, the things that third parties create at those institutions or accelerators who you want to work with, right? So if you're hiring someone on and you're hiring them on because they've got some sort of key you know-how, but it turns out they acquired that from while they were at a university. So, you know, just things to keep in mind when you're starting out, to the extent you're working in any of these environments.
Hey,
Yeah,
Pete, Daphne.
I'm gonna, oh, sorry, go ahead. Yep.
So wanted to make a point, but also want to just point out people are chatting.
Yeah, and I'm just about to respond. Yeah, but go ahead, Matt. What's your point?
Yeah, and just so everybody knows, I'm Matt Kirmayer. I'm also a partner at Perkins Coie. I do startups. I've been involved in the Venture Bridge program for years now. I think one very simple critical point to make, and Daphne and Pete have alluded to it, is whether you start a company by yourself, with a friend, with a co-founder, you start it with people and then others join, or whether you're getting intellectual property from a university or any other context. The idea is, if you're going to build a successful startup, and the goal of a successful startup is to grow, raise money, become a bigger successful company, at the beginning and at every moment in time, you need to make sure that whatever technology, whatever intellectual property, whatever rights you need, you either own, meaning the company owns, or the company has properly obtained the right to use that commercially. And I'm never here to plug lawyers, but you can't do any of this without qualified lawyers. It is, as I hope you can tell, it is complex and tricky, and there are a lot of elements to it. So.
Okay, I'm just going to answer some of the questions right now. One was, do trade secrets have to be registered with a federal, state, or government agency? And they don't. Trade secret, one of the requirements for something to constitute a trade secret, and then it looks like Matt's kind of, I mean, Pete's moving up there, but it needs to be kept confidential. So Pete mentioned, you know, the secret formula for Coca-Cola. That is kind of the classic trade secret. And then another question is, if you patent with the university and the university owns the patent, can you buy it? So usually universities structure it where you get an exclusive license to that patentable material. And that means that you can do everything you want with it, almost like an owner, so almost like buying it, but you don't have full ownership. An exclusive license is absolutely fine. The reason many universities do not allow you to buy it is that it's the university's policy to create an environment where whatever they own with respect to IP is used for the benefit of the public, or that it's actually commercially exploited. So that's one of the reasons why they like to retain the ownership rights, but give an exclusive license. And as I said, an exclusive license it's almost like ownership. So it's very good, and investors will look and they'll want to see if you have an exclusive license. They do not need to see that you own it. So again, just as good as ownership. Now let's see. Do you want to take the next one here, Pete? This is about if we trademark a title name in the US, can someone use the same name in a different country?
That is an interesting question. I'm not. Yeah. So I think given that trademark registration is national, then someone would be able to register that mark in another country for use in another country. Yes. I don't know the specifics of of transnational registration regimes, but what you would want to do is make sure that anyone with whom you're contracting is obligated to only use that trademark in certain ways and subject to your approval. Whether or not someone in another jurisdiction, overseas or something, is going to be able to register a similar mark, often not within your control unless you want to go try to register the mark overseas. But you would have rights, the exclusive rights in the United States were that mark registered. You also have rights in the United States if the trademark is not registered. It doesn't have to be a registered trademark for you to have trademark rights over it.
Yeah, and so just to add on to that, you can register. Plenty of times we do. We coordinate with foreign counsel to register trademarks in other countries. It really makes sense only if you're doing quite a lot of work or selling your products in those other countries. So it's something that you would sit down with your attorney, try to figure out, does it really make sense given the costs and time to do it, and then go ahead. What I think I've seen is it's usually companies that have now opened a foreign office. That's when they start registering the trademarks abroad in those specific locations where they have offices. Rarely do I see a startup doing that. Even if they have nominal sales outside of the US, it's not until they really get ramping up that they would consider registering the trademark there. And I think we have one other thing about trade secrets. So about trade secrets, even with signing NDAs with any third party, how can you track who reveals the secret and act on it? Well, you can't. I hate to say it, it's so hard to police so many of these things. The key thing though is if you are making sure that you have a trade secret in the sense of signing those NDAs before you reveal anything, so you definitely under the law have a trade secret. When it does happen that someone else, you find out someone's utilizing that trade secret, the law is on your side in the sense that you can stop them with an injunction, like stop using, and then you also can sue them for damages. So it's really, as I said, hard to police, but there are a lot of things that you can do to prevent things leaking out. And that's, only sharing sensitive information with the people that need to know. Making sure that even if you're like going to an investor or talking with a potential partner, that when you're sharing the information, you're only sharing limited amounts of information. So it's not like that you're letting everyone see, your sensitive IP. So those are the things. You just have to be very cognizant with whom you share things.
Hi, may I ask a follow-up question on,
Sure.
about that? Because I asked that question and I have a follow-up question. So I know, for example, for patents, you have a couple of claims and there is a high level of like scrutiny, making sure that those claims are right. But for trade secrets, you basically think that there are secrets in the company, you have some IPs, and how can you like, again, with the NDA there are a lot of things, but how can you like, and you're not registering it with federal agency as you mentioned, so how about these claims? Like, how can you say that these are not obvious things to others? Like, if you, for example, talk with a partner or with a third party, and then you discuss some stuff, and even though you sign an NDA, and like later on it happens that some of these has been leaked to others. How it's My question is, like, specifically, since you don't have that structured way of patent and claims, how can you protect all these things that you believe are secrets, but the other person might not see them the same way?
So it's making it very clear to the party that this is a secret and it cannot be disclosed. Obviously, as you said, getting an NDA. If this is truly outrageously sensitive and something that's patentable, what we do suggest to folks is file a provisional patent prior to disclosing the information, because then you can lean on the patent to enforce your rights. If it's a trade secret that is not patentable, then it's merely limiting what you disclose to others. You know, if you're talking to a potential partner, then relaying some of it, but not giving them the nuggets that you're really concerned about. So you're going to have to, you know, entice a party and talk to them about things, but not share all of the details. That's the best way to protect trade secrets.
Yeah, and I just piggybacking off that, it sort of segues into the next slide, but you really, you know, you protect trade secrets by contract, right? Obviously, there's one way to protect them, which is just to not disclose them, or to, you know, ensure that they're always marked or something like that. But the protection really is given to you by your contracts and by your NDAs, and how you define capital C, capital I, confidential information. Generally, if you're the party if you're entering into an NDA and you're the party that's going to be disclosing a lot of information, you like to define confidential information broadly. Just sort of any information that we disclose to you, you know, under this relationship is going to be considered confidential. You're gonna keep it secret. You're not going to use it except for the limited purposes that we describe in the agreement. And that way you've basically covered all your bases, and you don't need to get into a disagreement about whether something's a trade secret or not, because you've defined pretty much everything you're disclosing as confidential. Obviously, the converse of that is if you're going to be the party that's mostly receiving confidential information, you'd want to limit that definition somewhat, so that you're not, you know, you're not bound by obligations if something's disclosed to you that's not really confidential. But yeah, you know, having a broad definition for confidential information will ensure that any information that you disclose by and large will be protected, and you don't need to get into the mental gymnastics of, is this a trade secret, is this not, how secret is this, you know, things like that. Did we cover the question?
I think so. Did anyone have any other questions?
I have a question about provisional patent. So I read somewhere that it doesn't provide the same amount of protection, or it cannot even provide good amount of protection similar to a patent that is granted. So I wanted to, can you explain a little bit like how a provision patent works and how can it protect your IP?
So let's say you got, and that's a really good question. So a provisional patent is, you're absolutely right. The details that go into a provisional patent are not at the level of the details that go into a standard patent application. The provisional patent is for 1 year, and then you must, within that period, file for a standard patent, or everything just fades away. So what is, like, if you have a provisional patent now, let's say, and you find that some other party is utilizing your IP, you can enforce your rights, but it will be a little bit more difficult, because your rights really haven't vested until you have a true patent. So what usually happens is that a provisional has been filed. Someone, you find out that someone is utilizing your IP, and you want to prohibit them from doing so. And so ideally, you move your patent forward, get that patent finalized, and then you're in a better position to bring a suit. Less challenges once you've got the patent in place, more challenges from the other party, and more difficult to defend when you're in that provisional stage. But it's still really good to be there than not having done anything at all. And the one thing attractive about a provisional, it's going to cost, less than $2,000, but putting in a patent application costs substantially more.
Thank you so much. I have a like a particular example I wanted to ask. Like, imagine that there is a company out there that is doing something, but they haven't patented what they do, and then another company just start to do a patent longer after that company having revenues out of their product. Can the second company, the company B, can they enforce the patent rights on company A, which was in the business for a long time, but they haven't patented their idea?
Not sure I got that. Maybe the best thing is we can take that offline. Does that
Sure.
work for you?
Yeah, thank you so much.
Yeah. Okay, good. I think it's just gonna take a little bit more, and I would have to ask you a couple more questions, and I'm a little concerned about time-wise getting through everything.
Sure.
But thanks, we can connect
Thank you.
later.
All right, I think we talked a lot about NDAs, so I'll just, one final comment, whenever you're disclosing anything that you consider to be sensitive to your business, be sure you have an NDA in place. All right, let's get to the IP licensing portion of this. So what is an IP license? An IP license is basically a contractual permission to violate your IP rights. It's basically to say, hey, look, I have these exclusive rights in something. I have exclusive rights in my book, but I'm going to let you copy it. I'm going to let you make 10 copies at $1 per copy, and there's your license to do that. So at its very core, an IP license is taking an exclusive right that you have and granting others the rights to also participate in that. And that's how you monetize it. Otherwise, you just have an exclusive right that is yours and you're just sitting there with, and that's great. But you want to be able to commercially exploit something, you need to grant a license to it, as opposed to obviously you wouldn't want to grant ownership of it. You wouldn't want to transfer the IP rights. So what we do is we license it.
Yeah, and so that license will grant the other party the rights, but also in that license, you protect yourself. You make it very clear you're the owner. You make it clear that you're going to get X amount of dollars or some equity or some sort of benefit out of giving this right to another party. And it sets forth all of the different terms about your relationship with that other party. Like, can you terminate the relationship? Can you change the pricing? Exactly how can they use that? I mean, you might want to give your IP to someone so they can use it in exchange for X amount of dollars, but you don't want them to go out there and start licensing your IP to a whole bunch of different people, because if they do that, you're losing out on that money. If you want them to do that, you should certainly get a cut of what they get from the other parties. So it's it's a clear agreement between the two parties with respect to each party's rights.
And then we talked a little bit about this, but why would you license? You obviously want to monetize it. You also want to, piggybacking off Daphne's comment, you want to exercise control. You want to sort of say, here's what you can and cannot do with the licensed IP. You can also use licensing agreements as a mechanism to deviate from background legal principles. For example, there are certain generally applicable statutes that imply certain warranties when you're selling a good, and licensing of software is often considered a sale of a good. So you can disclaim those warranties in your licensing agreement by saying, hey, notwithstanding anything in the generally applicable background law, I'm providing this software to you as is, without any warranties that it's going to perform in accordance with any of the documentation or any of the specs. Another reason is to limit your liability and to allocate liability. To make sure that who's responsible if there's a lawsuit based, if a third party comes and sues based on the IP, right? Things like that. We'll be talking about that in a little more detail later. But those are sort of some primary key reasons why you would want to license.
Yeah, and what we kind of see too is in these agreements, there's a bit of a give and take, right? If you're saying, here's my software, you can use it, and you can use it for A, B, and C purposes, but I'm not going to provide you, if it turns out that my software, parts of it were stolen, and you get sued by the party from whom I stole parts of the software, if you don't provide anything that protects the other party, then you're probably not charging them as much. So there's this kind of give and take. If they're paying more, you're probably going to provide them with additional benefits. Whether that's additional rights to use the software or protections to them, saying, let's say there are no bugs in the software, or this software is all made by us, and no portions came from another person. So there's this kind of flow of, if you are getting more money, there tends to be more rights or more protections that you're providing.
So, you'll typically see, obviously, a license grant is from one party to another party. And when you're drafting a license grant, one thing you'll always want to make sure that your lawyers are watching out for is that the grant must be present. So if I say, if you're going to grant a party a license to use your software, you have to say, I grant you a license to use my software. You can't say, I agree to grant you a license to use my software, or I will grant you a license to use my software. that's not an effective grant. The grant must be what we call a present grant. So I grant you this. Usually you use the words hereby, but you don't have to. It just needs to be a present grant. You know, each license should clearly identify who's granting the license and then who's getting the license. You will sometimes you're dealing with a large entity that has a bunch of subsidiaries, for example. So if you're granting, let's say you're granting a license to Amazon to use your software, does that license grant go only to the Amazon parent entity, or are there other entities that get to use the software within the Amazon corporate umbrella? Not a super typical problem that our startup clients face, but you know, as you scale and you work with bigger companies, you'll want to watch out for, you know, just exactly who you're granting a license to.
Yeah, and that's this is a trick that sometimes I see. You know, I'm representing a startup and they've got these really attractive deal with a big public company, and they're talking about pricing and things like that, and the big public company is saying, well, you know, we'll pay you X amount each year for our use. And then you find out the use goes to that, you know, as Pete was saying, the parent company and all of the subs. Well, that's going to suck for you, because you could have, if you individually licensed to each party, or said, look, we're only doing it to the for the parent. If you want to include the subs and allow them to use, then you need to pay us more. So I see that quite often. You know, looks really good, enticing, and you know, the client's really excited. And then once we really get into the document, we realize that, you know, you should be making more out of this deal because a lot of people are using it.
And you know, just not to belabor the point, but one more comment on this. You know, the more subsidiaries or entities within a corporate umbrella that are using your software or your technology and the underlying IP rights, the less control you have over it, the less visibility you have into it. So it's definitely a trick that can serve to benefit the licensee and hurt the licensor. You'll want to specify what type of IP you're licensing. I won't go too far into this one, but you know, if it's copyrightable subject matter that you're licensing, you know, you grant a license if under your copyrights. If it's under a patent, that's typically where we see a lot of language about, you know, exactly what rights are being licensed, because you'll be licensing a product that's covered by a certain patent that you have. And if you say you have a patent portfolio, you have, you know, 10 patents in your patent portfolio, you've been awfully successful so far, and you're licensing a product to which only 1 or 2 of those patents apply, you will want to specify that, hey, I'm granting you a license under patent number 1 and patent number 2, but no other patents. So that's where you'll typically see, you know, exactly what licensed IP is being, or that's when you'll typically see a call out of specifically licensed IP.
So, hey, I just noticed that we're kind of getting tight time-wise, and there's one thing that I want to, well, want to make sure that we have time for some additional questions, but I do want to touch on this whole license. I mean, it's interesting because you'll get a document and it'll seem like it's relatively fair, and as a startup, usually you can't use your own paper. You know, you're contracting with more established companies, and you know, they're forcing you to use their document. And actually, even if you are creating your own document, the thing to think about is this document is outlining your relationship with the other party. And all of the terms in there are very critical. And there are tricks that have been played. And so you have to read through it and you have to kind of think of what you actually want out of the relationship. And so I'm going to jump ahead to one trick that comes up quite often, and I just had the other day where I was representing a startup. The larger entity said, you know, we're fine with all the pricing, everything looks good, but let's, you know, they put in there a term of 4 years, which sounds really attractive because you've got a, you know, guaranteed revenue for 4 years. But the downside was, given there was a 4-year term and no ability to change the pricing, you're stuck with this price that you set at the very beginning for 4 years. And that's probably not a situation you want to get into. Again, while it's terrific to have that guaranteed revenue for a period, what you want to do is to ensure that you can increase the price during that 4-year period. I see that all the time where people are stuck with just like pricing that isn't attractive, and they have no means of changing it and no means of getting out of the agreement unless the other party hasn't paid. So again, I know I'm kind of gassing on about this, that I just really want to make it clear that those terms and the agreements that you have with other parties when it's about your IP are outrageously important, and they all need to be looked at in the simplest terms that you think, yeah, whatever, can be problematic.
Okay, so if we have 5 minutes, should we skip down to the, did we cover all, I think we covered most of the gotchas.
Yeah.
I think we're probably okay, so maybe we'll just sort of try to power through the last of these. We're about halfway through our slides, but we'll try to power through sort of the rest of the license agreement, so everyone can sort of see what we're talking about here. When you grant a license, you want to grant the rights that are granted to you by statute. So, you know, copyright, for example, you have the exclusive right to make copies. You'll want to make sure the license is specific as to, okay, if I'm only going to grant them the right to use copies, I grant you the right to copy. You know, you don't want to use extra words in, you know, extra rights unless you have to or unless you want to. So the verbs should match the type of IP.
Yeah, and one thing on the, and I don't know if it's on here, but one thing that, not talking about the rights, but talking about the actual thing that you're licensing. And let's say it's some code that you're licensing. You want to make sure that definition of what you're licensing is very clear. Because a kind of another gotcha is that you say, oh, we're going to license this software product, and, you know, our improvements and updates and upgrades. And now a party has a whole bunch of IP that they have access to. And while that's fine, you want to just make sure you're actually getting paid for that. You know, what I've seen is that, you know, we were in a deal where, you know, we got the document after the fact, and a product was licensed, and then it pointed to an exhibit and said all of these updates, upgrades, new products. So the company is now bound by an agreement where their new products, not just the core product that they thought they were licensing, but their new products are being given to the other party for the fee that they had allocated for their core product. So they've just missed out on a whole bunch of revenue there.
Some other things you're going to want to consider when you're granting a license: exclusivity. Are you granting a party exclusive rights to use your licensed IP, or is it more typically we see non-exclusive? Be careful when a party's asking for exclusive rights. That's something you'll definitely want to loop your counsel in and give a lot of thought to. Territory, sometimes, you know, you might want to be licensing your software on an exclusive basis to a party in Canada and to a different party in a different part of the world. So you'll want to think about that, whether there's any territory limitations. Royalty or payment obligations. So, you know, if you're granting a party a right to create a product, say that's based on a patent that you own, what type of royalties are you going to get back for that, right? They go sell the product at market for $100. What are you going to get out of that $100? Transferability, can this party, the party to whom you are licensing, can they transfer that license? Kind of related to sub-licensing and related to the point we were talking about subsidiaries and affiliates and whatnot. Is the grant of the license, I'll use the word personal, but is it personal to just the licensee, or are they allowed to transfer it or sub-license it to other parties? Something you'll want to specify in the document. And then, you know, is it irrevocable or is it revocable? Under what circumstances can you revoke the license? You know, if you grant a license for a specific term, so if it's term limited, I grant you the license to produce copies of my book for 3 years, then it's implied that the license is going to end. You know, it's always useful to specify that it's revocable, you know, as that will bear on other parts of the agreement, right? If the licensee is in breach, you'll want to revoke the license, things of that nature.
Yeah, and like just a quick point, all of these points here, going through them, all of them relate to money. And sorry, the fixation on money right now, but you know, if you license something to someone worldwide and you know that you could generate some revenue in other areas, then you may want to split it up and say, you know, I'm going to license to folks in Canada, I'm going to license this in a certain area of the US or whatever. So you've got to kind of think about all of these concepts and, you know, how is it going to help you from a marketing perspective? How is it going to help you from a revenue perspective? You know, how does it help you vis-a-vis competitors and so forth? One last point on the royalty. What I see a lot is people asking, I want to get a flat fee here on this IP that I'm using, and I want to be able to put it into, you know, connected or incorporated into my own IP and then sell it to a third party. Well, you may say to them, okay, we'll let you do that for a flat fee, but in addition, anytime you sell to a third party, we want 10% of that. So you are getting that flat fee in, but in addition, you're getting part of the upside that they make from utilizing your IP. And I think we're actually, Pete, getting to the very end here. It's 10:32. Sorry, folks.
I'm thinking maybe we talk about term and termination real quick, and
okay.
And that might be the last thing we have time to cover. You know, this is something you'll want to work out in all your license agreements, right? What is the term of the license, and what are your termination rights? You know, typically the term will impact the pricing, as Daphne said earlier. So if you're giving you're getting a 5-year deal, you're granting a 5-year licensing deal, you might be collecting less money up front or collecting less money on an annual basis, but you'll be getting more money, obviously, you know, in the aggregate. And whether, you know, you'll also want to think, well, during that 5 years, what if in year 3 I'm really killing it as a company and this pricing is way outdated? Am I going to have a mechanism for changing that? Yeah, you'll want to think about those kind of things, and then really to think through termination, right? If you're a licensor, I mean, typically what's best for for our clients is one-way termination for convenience. Basically, we can get out whenever we want, and when we get out, the only thing that happens is the license dies, and we settle up on any fees that are owed, and then we go our separate ways. Typically, if you're a licensor, that's going to be hard to swallow for a licensee. You know, I find it very rare to be able to get termination for convenience, but you'll still want to think about what your you know, what your termination rights are and what the termination parameters are. You will often see a licensee getting the ability to terminate for material breach, or at least asking for it. And if they do, you should try to make sure that all the fees are paid up front, either up front at the very beginning of the contract, which is tough, or up front on an annual basis. And you'll want to stipulate that, hey, they're non-refundable. So yeah, you can terminate for convenience, that's great. But once I've collected your money, I'm not giving any of it back. So yeah, always want to think about termination.
And just to step back a teeny bit, when we're talking about term, we're talking about the period you're in a relationship with the other party. And, you know, Pete mentioned licensor, licensee. You as the holder of the IP and granting the other party to use the IP, you're the licensor. And the person getting to use your stuff is the licensee. Anyway, I think we're kind of at the end here. Would love to do more with folks, so hopefully we can connect again another time. Want to ask though, before we you know, completely stop, does anyone have any questions? Okay, well, want you to know that feel free to, I think the very first slide, we showed have our email addresses. Please feel free to reach out to us with any questions. And do we there? No. You have our names. So I'm D. Higgs at perkinscoie.com, and Pete right there too. I think everyone knows Matt. He's also at Perkins, of course, and we're all here to help you. You know, so definitely feel free to reach out whenever.
Thank you guys for leading the workshop.
Thank you both.